Good evening, hello and welcome to this special broadcast. I'm Anusha Soni. The Supreme Court of India has handed down a historic verdict, upholding the 103rd Amendment to the Indian Constitution. The Constitution bench, by a majority of 3:2, laid down that the economic status can be the criteria for reservation in India. Also, the 50% ceiling in overall reservations prescribed by the Indira Sahni or the Mandal Commission case can be breached, provided that the government has created a new class in itself. Like in this case, economic reservation 10%. Well, that's the ratio that emerges from this historic judgment. It is indeed a watershed moment. But here's moving to the implication bit. While the Antyodaya mission of the present government means creation of a more egalitarian society, devoid of caste lines, but has this opened up a Pandora's box? If the government can create a new class and reserve 10%, can further classes be created? In the words of Justice Pardiwala, remembering the vision of Baba Bhimrao Ambedkar, reservation cannot be a permanent feature of Indian Constitution. Today's judgment does not touch upon the reservation for SC, STs and OBC, but by allowing reservation based on economic status, clearly new dynamics, new paradigms have been opened up on this already very vexed issue of reservations in India. Our top focus this hour.
माननीय सुप्रीम कोर्ट का कहना है कि ये जो EWS कैटेगरी है, ये कहीं से भी जो कास्ट बेस्ड रिजर्वेशन है उसको कॉन्फ्लिक्ट नहीं करता, ये किसी भी कॉन्स्टिट्यूशन का वायलेशन नहीं करता, आर्टिकल 14 का वायलेशन नहीं करता।
I don't oppose EWS reservation. I definitely oppose the mindset of the Supreme Court. Isn't it the mindset of the Supreme Court that the biased mindset?
Well, there are some judgments that come from the top court of the country that are a watershed moment. This one is indeed one of them because it upholds a change in Part 3 of the Indian Constitution. A pro-poor quota has been upheld. And what does it mean when you give reservation based on economic status? Many would say this facet was not known to Indian Constitution, at least in the basic structure or in Part 3 of the Indian Constitution. Quota on the basis of one's economic status is good in law. It's not violative of the basic structure of the Indian Constitution. Quota for economically weaker section doesn't violate the Constitution. It is in line with various judgments and the Constitution bench judgments of the Supreme Court. Centre can create a new class for reservation. The central government said, Indira Sahni, 50% ceiling only for SC, ST, OBC. 3 classes. This is a new class that we are creating. We have the power to do that. Vindication for the affirmative action based on economic status. This is a positive step that the government has taken. It has not taken away the rights and privileges of any particular community. 50% ceiling limit can be breached in exceptional situation. What are those exceptional situations? Like one where the court has said that the government has the power to create a new class. What are the criticisms? There are criticism coming in. None other than the Chief Justice of India and Justice Ravindra Bhatt have dissented. But various political voices coming in. Undermines the fabric of social justice. The entire argument that reservation is about, in some way addressing the historical injustices. It's about caste and a homogeneous group. It is not about the economic status. Discriminatory, excludes the communities historically sidelined. SC, ST, OBC will not be covered under 103rd Amendment to the Indian Constitution, the new parts introduced in 16 and 17. Stated purpose of quotas to enable representation, not financial upliftment. This is a very important point that one needs to understand, and it coincides with deprivation versus discrimination issue. When the constitution makers had gotten reservation in our country, the entire idea was to give the underprivileged communities some kind of say on the table, a seat on the table, so that they can be represented. One of the arguments that the petitioners had advanced were that reservation is not tool for any kind of financial upliftment, and if the government wants to do it, use your welfare schemes. but the majority disagreed. And joining us on the broadcast is our legal correspondent Ananya Bhatnagar, who is with us on the show. Ananya, very interestingly, even the judges who upheld the 103rd Amendment to the Indian Constitution said that reservation is not a permanent feature. And we must think about the times when we can fulfill the vision of Dr. Ambedkar, and reservation at some point perhaps can be done away with.
Well, definitely, Anusha. It's the view that's been given out by both the dissenting judges and also the concurring judges, clearly saying that reservation is no permanent solution and it was never there for, in fact, an indefinite time to be there. And that's the reason why, in fact, Justice Bela Trivedi in her piece of judgment clearly says that even after 75 years of independence, we shall actually relook into this particular structure of system, while on the other hand we hear from Justice Ravindra Bhatt and Justice, in fact, the Chief Justice of India, UU Lalit, about how the exclusion of, in fact, the economically weaker section, the SC, STs and OBC, the economically the backward classes would actually result into the disruption of the social fabric of the country. But at the same time, the concurring judges actually say that reservation is not something, though it's a very important provision for the Constitution of India. It's an affirmative action under the Constitution of India, but then it is not such an affirmative action which is not actually inflexible or cannot be modulated with it. But it is something that has to be looked into with the changing times, and in fact that's the reason why two of the judges, Justice Bela Trivedi and Justice Dinesh Maheshwari, and Justice J.B. Padiwala clearly go on to say that a reservation system shall be relooked into at least after 75 years of independence, when almost 7 decades have passed in. And remember that when, in fact, then Attorney General Mr. K.K. Venugopal was arguing this particular case, he was representing the central government. He had said that the point of equality that the petitioners are claiming with the economically weaker sections of the general category is not something to be correct, because already the SC, STs, the OBCs who are backward classes have already had those loads of benefits in the form of reservation
and in no way, Ananya, as the Attorney General also pointed out, those benefits are being touched by the government, and that's the written order copy also that my colleague Ananya was elucidating upon. That that's what the court has said, that the entire idea of reservation is not so basic or intrinsic to the Constitution that it cannot be further evolved. That's the idea that the court has mooted upon. Thank you, Ananya, for joining us on the broadcast and getting us all the details on that very important story. What are the implications of this judgment? Politically, how will it translate? What kind of ways and methods does it open to various state governments? How will this really be implemented on the ground? These are all the questions that need to be addressed in the times to come. Joining us on the broadcast